Hello, and thank you for being here. My name is Todd Fuqua. I serve as Network Building Lead for the HIV Modernization Movement Indiana, and I've been living with HIV since 2012. This presentation reviews preliminary data on how Indiana's duty to inform statute is being enforced, and what that means for lawyers practicing under a statute change made in 2020. I want to acknowledge the contributions of my colleagues, Dr. Carrie Foote and Phoenix Schlebecker, who led the preliminary research. Indiana criminalizes non-disclosure of HIV in certain sexual and needle-sharing contexts. In 2020, the statute narrowed liability to only acts involving CDC-defined significant risk. That change matters because it alters what must ultimately be proven to sustain a conviction. Today, we're looking at publicly available court records to understand how the law is applied. Preliminary analysis suggests some attorneys may not be fully aware of the recent changes to the law or may not know how to effectively support people who are charged under it. This work is a collaboration between Indiana University researchers and the Williams Institute. The focus today is on the enforcement of Indiana's duty to inform law as applied to people living with HIV. The analysis looks at charges, outcomes, and the context of these cases. This research focuses on two interrelated statutes, one in the Health Code that defines disclosure requirements for people living with HIV or hepatitis B, and one in the Criminal Code that defines penalties for failure to comply with those requirements. Under these laws, failure to disclose health status can result in a felony charge. In 2020, House Enrolled Act 1182 added the phrase "as determined by the CDC to bear a significant risk" to the statute. That language ties criminal liability directly to transmission science. To sustain a conviction, the state must establish three elements: knowledge of HIV status, failure to inform, and conduct that bears a significant risk of transmission under CDC guidance. The third element is essential. Without CDC-defined significant risk, the offense is not established. So what does CDC-defined significant risk actually mean? The CDC recognizes that a person who is durably virally suppressed does not sexually transmit HIV. This is also known as undetectable equals untransmittable, or U equals U. Oral sex carries negligible to low risk. Condoms significantly reduce risk. PrEP is highly effective when taken as prescribed. The statute now incorporates this scientific framework into its definition of criminal exposure. The researchers identified 61 duty to inform cases from 1998 through 2024 using administrative court records. Probable cause affidavits provided data to understand how cases were initiated. 10 cases occurred after the 2020 statutory revision and were reviewed separately. Let's look at who's being charged. Defendants were predominantly male and disproportionately Black, with an average age of 36. The majority of cases involved straight sexual relationships. Of the 61 cases identified, most occurred in Marion County, followed by Monroe County, and Vigo, Madison, and Huntington counties. No identified cases involved hepatitis B only charges or allegations involving needle-sharing partners. The rate of new cases has dropped since 2018. In 2020, liability was narrowed to conduct that bears CDC-defined significant risk. Arrest may occur on probable cause. Conviction requires proof of each statutory element. The high-risk element is now central. In reviewing probable cause materials, we consistently see documentation of knowledge, allegations of non-disclosure, and evidence that sexual contact occurred. What is not consistently reflected is detailed CDC-based transmission risk analysis tied to the alleged conduct. Available PCAs do not consistently document the route of sexual exposure, condom use, engagement in treatment, viral suppression status, or CDC risk classification. These factors are directly relevant to determining whether conduct meets the statute's high-risk threshold. In the 10 post-2020 cases reviewed, evidence of HIV treatment appears in 4 PCAs. Viral load or U=U documentation is not mentioned. 3 cases involving low-risk acts were resolved through plea agreements. We do not have access to full litigation files, so we cannot assess how risk was evaluated beyond the charging stage. It's important to distinguish arrest from conviction. Arrest may occur on probable cause. Conviction requires proof beyond a reasonable doubt. After 2020, high-risk activity, as defined by CDC science, is an element of the offense. If that element is not established, the offense is not established. There's one core reality we have to name before we move into defense implications. The HIV transmission science is clear. The statutory framework incorporates that science, but Indiana courts have not yet squarely resolved how those two interact. This slide separates science from precedent. The statute hinges on CDC-defined significant risk. Since the 2020 revision, every known case has been resolved by plea. No jury findings, no appellate interpretation. No Indiana court has ruled on whether viral suppression or low to negligible behaviors defeat the statutory element. For defense counsel, that uncertainty creates both risk and opportunity. The burden remains on the state to prove CDC-defined significant risk. Appellate silence is not a rejection of the science. It means the science must be put in the record deliberately and precisely. So what does deliberate and precise litigation look like? For public defenders, the central question is whether the state can prove that the alleged act meets the CDC's definition of significant HIV transmission risk. Viral suppression, route of exposure, condom use, and PrEP are not mitigating factors. They are relevant to whether the statutory element is satisfied. Counsel should require the state to clearly define the CDC standard it relies on and to present evidence establishing that standard in the specific case. Where CDC-defined significant risk is not established, the element fails. Even in the absence of definitive appellate guidance, the state still bears the burden of proving that element. It cannot be presumed. This slide synthesizes what we've discussed. The statute requires CDC-defined significant risk. Charging records typically establish knowledge and allegations. The evaluation of significant risk becomes critical as cases proceed. Defense counsel must require articulation of CDC-based risk tied to the alleged conduct. If CDC-defined significant risk must be proven, are we requiring that proof? This analysis is based on administrative court records and probable cause affidavits. We do not have access to full evidentiary records or litigation materials. Further analysis is needed to determine how significant risk is evaluated beyond the charging stage. Resources for legal support, scientific reference, and policy guidance are provided, including materials that align practice with evidence-based understanding of HIV transmission. You can view the full research poster and additional materials at the last resource, hivmodernizationmovement.org/research. Thank you for taking the time to learn about these findings. If you support efforts to modernize Indiana's criminal laws, we encourage you to sign on in support of reform and join our newsletter listserv. Please feel free to contact us at foot@iu.edu or ctfuqua@me.com with questions or collaboration inquiries.